Welcome back, everybody. It's the lawyer you know, and today we're giving our final pre-trial update on the Kyle Rittenhouse case. So if you're interested in this trial and you're going to be following along weekly with us, make sure you like this video so we know you're into this content and you want to see and hear more about this trial. So we will continue to bring you videos on this trial. And if you're interested in any other case that's in the news, let us know and make sure you subscribe to our page. We're getting closer and closer to 20K every day, and we're trying to hit that benchmark before the end of 2021. So the most recent big event to happen in this Kyle Rittenhouse case is the October 25th pretrial hearing. It's the final hearing to basically set the ground rules for trial, where they went through all of the outstanding motions in limine and discussed the experts and whether or not the experts were going to be able to testify at all. And if they were able to testify, what are they able to testify to? The judge basically said we're having a Daubert hearing, which is a hearing to determine whether or not these experts are qualified to testify to the content that they want to testify to. So I think one of the overarching themes of this hearing is that this is going to be a good trial. I think we have a good trial judge who did a lot of research. Now, he definitely seems like he's leaning a little defense heavy, and he's giving the defense the benefit of the doubt throughout this trial to put on their case to try and prove self-defense. But I would say the reason I think this judge did a great job is, first off, he was very prepared. He read through all the motions. He read through all the research. He looked back at other cases that were similar to this case. He was even the presiding judge on a case that was similar to this case over 20 years ago. So he's very experienced. I think he's going to do a good job throughout this trial, because the number one thing I like about judges, trial court judges in trial, is that they are willing to make a decision. They are confident in what they have read and what they know the law to be, and they make a call. The worst thing is when a judge sits there and says, can't you guys just come up with an agreement? I'll reserve ruling on this. I'm not going to rule on that yet. I don't know. Let's just wait and see what happens. And again, this judge did that here and there. Let's see what happens at trial and I'll make a decision in the future. But for the most part, the judge gave the lawyers the indication of which way he was leaning and what is going to be allowed at trial and what is not going to be allowed at trial. So let's start there. Some of the state's motions in limine that were still outstanding that people care about are, first, the use of words like rioters, arsonists, and looters for these alleged victims in the case. The judge is going to allow that terminology to be used by defense attorneys if they can provide evidence that these alleged victims were in fact rioting, committing arson, and looting. And I think one of the things that we saw the judges, where the judge feels on what was happening back in 2020 is that the prosecutor tried to downplay arson. Big deal. They were lighting fires in dumpsters. This looting and this rioting that was happening was nowhere near where the shots actually were fired. So no big deal. We shouldn't be able to talk about that. The judge said, are you serious? Do you hear what you're saying right now? Arson is no big deal. They were pushing these lit up dumpsters towards gas stations, which could have caused a huge explosion. The fact that the alleged victims were saying things like, I'll kill you, and they had a gun, some of them, and they were hitting him with skateboards. You don't think any of that is relevant? Do you hear yourself? Basically saying you prosecute crimes like this, and now you're saying they're no big deal when it suits you? I think that showed kind of how the judge feels about this, so he is going to let that in if they can prove it. What's interesting, this judge never allows use of the word victim in criminal cases. And the prosecutor made a good point. He's saying, even after I've given evidence that this person is a victim of the crime that the defendant committed, that the evidence shows, at least I have a reasonable basis to believe it shows, you still don't let me call him victim. So why is that fair? The judge says, oh, that's different. Now, I don't necessarily agree with the judge. I think they should at least be able to call them alleged victims, right? Because they're not proven victims until a conviction happens, but you can say alleged victims, right? I think that this is kind of semantics, but the judge is drawing a line saying, nope, you can't call them victims. Yes, you can call them arsonists, rioters, and looters if you provide evidence. The second thing that everybody basically agreed on is everyone is going to be called Mr. or Ms. and whatever their last name is, with one exception. The judge said that the defense attorneys can refer to the defendant as Kyle. And it's not because he's a minor, and it's not because of sympathy. The judge said that's a standing rule in his courtroom because the jury assumes a different kind of relationship between defense attorney and defendant. They have a working relationship. They know each other well. It personalizes them more, so he allows them to call the defendant by their first name in every case, not just this case. So the third motion in limine surrounds a video of one of the alleged victims, again, saying threatening things, the fact that he was coming after people, potentially threatening people that were there doing what Kyle Rittenhouse was doing. And the state said this was remote in time, remote in place. It didn't happen at the time of the shooting, so it shouldn't come in, that video of him using racial slurs, cursing, saying he would kill somebody. And the defense argued it absolutely goes to what was happening around Kyle Rittenhouse that night. It goes to what his state of mind was, how he was having to react. They have an expert showing he was holding the gun safely until things exploded. And when they exploded, he had a reasonable belief that his life would be in danger because of all these things, because people were saying it. And they have a video specifically of one of the alleged victims saying it, but other people were saying things like that. So tensions were high that night, right? So this all goes to the mindset. And the state argued that this is exactly the same as you not letting in the prior videos of the defendant coming to his sister's aid, fighting 2-on-1 against a female, and showing that the defendant has absolutely no awareness as to what is appropriate force and appropriate self-defense, as he thinks a 2-on-1 fight is appropriate when his sister's on a 1-on-1 fight with another female. And the judge did not let that video in, so why are you going to let this one in? The judge said those are totally different. That happened at another time, another place, totally different circumstances. This video happened the night of the shooting. It was one of the victims, and the victim's propensity for violence and to potentially be an aggressor in a self-defense case absolutely is relevant. So the judge is going to let this kind of evidence in. Now, he's not going to let the pedophilia charge or the sex offense charge or anything like that come in about the defendants, but he is going to let their actions that night that were captured on video. As we all know, there was tons of cell phone video and security video taken of this night, and it's cutting both ways, right? So the defense is going to be able to use that, the judge said, unless something changes. And the judge kind of left the door open, and he said, I like to let evidence in, and I like to allow evidence prior to trial that you can use it, and if something comes up in trial that makes it irrelevant or inadmissible, I'll make the call then. But I'm not going to cut all this evidence out and later say, actually, you can use that after you've already done opening statements and asked questions to witnesses. And I prefer that as a lawyer, that I'd rather let more things in to start trial. And if they become inadmissible or we prove they're inadmissible, then you cut them out, rather than we have to totally lose them in our strategy of the case and how we're building the case after we've been prepping it for a year plus, like they have been in this case. And one of the things during this discussion that I enjoyed watching the hearing and think that the trial is going to go well is they're able to joke a little bit. I realize this couldn't be more serious. People's lives are at risk. People's lives have already been lost as a result of this situation, but we're lawyers and judges. We're working. We've been working so hard. It's really tense, a high pressure, high anxiety job to be a trial lawyer. And I think when you get comfortable and you know everything about the case and you're very prepared, you're able to do stuff like the judge said, do you want to talk about that prior video that I already ruled was out about the defendant coming to his sister's aid? And the defense lawyer said, Judge, I'm not one to relitigate an issue I've already won. And they cracked a joke a little bit, and then the defense attorney continued to argue. I also thought the defense attorney and the DA did a great job in arguing these back and forth. They both made great points. Another reason I like this judge is he wasn't a jerk to them. I thought the prosecutor a couple times overstepped how I would act as a prosecutor and interrupted the judge and stopped the judge from talking and kept talking over the judge. And while the judge didn't admonish him, the judge came down pretty hard a couple times throughout this hearing on the DA. So another motion in limine that was discussed in this hearing were comments made by law enforcement that night to Kyle Rittenhouse and others that were there, guarding these places that they were standing at, like the car lot. And the prosecutor wanted to keep all of those statements out, saying it had nothing to do with the shootings. And just because an officer may have said to them at one point, thanks for being here, or we're happy you're here, we really needed you, or whatever it may have been, that's akin to an officer pulling you over and saying, you did a really great job stopping at that stop sign, and now saying, well, you acted in self-defense appropriately on this night, and they were basically justifying or they were okaying Kyle Rittenhouse's actions. The judge, again, disagreed with the DA and agreed with the defense attorney, who made the argument that it's all going to Kyle Rittenhouse's state of mind, which is so important in a self-defense case with everything that was going on around him, including the fact that law enforcement knew they were undermanned and underpowered to guard against what was happening that night. And that all is going to be relevant to this case, and we're going to talk a lot about it. And what I thought was interesting as well is some new light has been shed on what the defense's strategy is going to be throughout this case. We all knew it was going to be self-defense. We all knew they're going to talk about state of mind. We all knew they were going to attack the alleged victims and say they were the aggressors. We knew that. But the state or the DA said, Judge, he has just confirmed what I have long suspected, that he is going to basically use law enforcement to say they condoned what Kyle Rittenhouse did, they asked for it, therefore it's justified. And the defense didn't come out and say, you're right, but they did say, we're not saying that the police justified this. We're saying that this all goes to Kyle Rittenhouse's state of mind. And what the prosecutors are afraid of is if it seems like the police were on board with what Kyle Rittenhouse did, if it seems like these alleged victims were really bad guys and the world's better off without them, that's going to turn this case into a justified shooting. It's going to be those alleged victims that are on trial. It's going to be law enforcement that's on trial, not Kyle Rittenhouse. And I do agree with the state's concerns there that this should be about Kyle Rittenhouse. It shouldn't be about, the prior acts. The acts of that night, I think, are relevant of the alleged victims, but the prior acts that they have done, and it shouldn't be law enforcement on trial. But I do also see the point of how this is relevant to what was going on that night and how it affected Kyle Rittenhouse's state of mind. So I think we're going to see a lot of evidence like that come in as to the madness that was happening that night and how a lot of craziness was happening on both sides of the aisle from everybody that night. And we're going to see how it affected Kyle Rittenhouse. All right, the last motion in limine that I'm going to talk about on today's video that they discussed in this hearing prior to getting to the expert witnesses and what they can testify to is the civil lawsuits. The state said, I don't really know what's happening with these civil lawsuits. I don't even know who the defendants are. I know it's the city, county, whatever it may be. I don't even know if Kyle Rittenhouse is a party, but we just shouldn't be able to talk about any of this. And before the defense attorneys could even make their argument, the judge pipes in and says, this is classic bias evidence. If somebody is suing the defendant for money and then they're a witness against him or a victim, alleged victim against him in a criminal trial, you absolutely can ask about that because they now have a financial interest in the outcome of this case. And the judge is 1000% correct. We do that in every case, civil or criminal. If you're filing other lawsuits outside of this case against the defendant, we get to ask you about that. Okay, and I don't understand why that's a big deal. Now, the one thing they discussed is whether or not the deceased victims, it can come in that they're filing lawsuits. The judge said no, unless family members or people involved in those lawsuits or have some kind of financial gain to get out of the estate, getting money out of these lawsuits testifies, then it can be used against them or asked about them to confirm bias. But that's it. But this is classic bias evidence. So those are all going to come in. And again, a lot of the terminology and relevance to the facts that were happening that night and videos of that night, the judge said, I'm leaning towards letting it in. So for now, let's let it in. And like I said, during the trial, if we kick it out, then we'll kick it out. But for right now, he wasn't granting these motions in limine by the state. Lastly, the expert witnesses specifically focusing on Dr. Black, who was going to testify as to Kyle's state of mind, and I should say Mr. Rittenhouse, to Mr. Rittenhouse's state of mind, to Mr. Rittenhouse's actions and whether or not they were justified and were actually self-defense, and break down the video, what was happening, how quickly it was happening, how that can affect decision-making, things like that. The state didn't want him to testify at all. The judge didn't seem to want to keep him out completely because he did add some value to the case and have some real backing for his determinations that he made and his opinions. But the judge ruled he's absolutely not going to be allowed to testify to anyone's state of mind because you can't testify to that, and you're obviously speculating on what somebody's state of mind is. So that's out. Judge was right in that call. And number two, he's not going to testify to the ultimate issue in this case, which is, was this a justified killing? Was Kyle Rittenhouse justified in using this amount of self-defense? Did Kyle Rittenhouse fear for his life and therefore was able to use life-threatening defense mechanisms in this self-defense case? He's not going to be allowed to testify that. That is the ultimate decision. That is up to a jury, and that is absolutely the right call by the judge. But the state basically said, listen, if all Dr. Black's going to testify to is what happened in the video, a timeline of the video, how quickly things happened, then I'll go ahead and remove my expert that was going to combat some of the things that Dr. Black said. The defense attorneys agreed. They made kind of an agreement right there between the lawyers. So the state's not going to call witnesses. The expert witness they were going to call in rebuttal for Dr. Black, and instead Dr. Black is going to be able to testify just in a limited capacity in this case. All right, so that should kind of bring us up to speed. But what's this trial going to look like? The state is going to paint Kyle Rittenhouse as a self-proclaimed vigilante who wanted and was seeking to shoot someone that night. He is an aggressive kid. He shouldn't have had a gun. Oh, there was also some discussion on the motion to dismiss. Sorry, I'm interrupting myself. They want to dismiss the gun charges, saying they did not apply to Kyle Rittenhouse because of the type of gun he had and the age that he was. And the judge said, For now, I'm not going to dismiss those charges, but we can talk about it more later as to whether or not this statute was actually supposed to include people in situations like Kyle Rittenhouse and whether or not it even applied to Kyle Rittenhouse. So that's going to be up for further discussion later. Sorry. So, as I was saying, the DA's office is going to paint Kyle Rittenhouse as a guy looking for trouble, wanted to go shoot these people like he always had. He is a, Proud Boys type of guy, even though they're not going to be allowed to bring in that connection. And that's how they're going to paint Kyle Rittenhouse. He had no business being there. He came there looking for trouble, and he got exactly what he wanted, and he shot these people, and he should pay for that. That's what the state's arguments are going to be. The defense's arguments are going to be the craziness that was that night. Kyle Rittenhouse was there to try to help and try to protect. And these people were threatening his life, threatening him with bodily harm. They were cursing at him, throwing racial slurs around. It was chaotic. They were rioting and looting and lighting things on fire and pushing it towards gas stations, trying to make explosions. They got in his face. They chased him. They were the aggressors. They hid behind cars, and Kyle Rittenhouse had no other option but to respond with deadly force when he was hit in the head with a skateboard, when things were thrown at him and projectiles were thrown at him, and when somebody came up to him with a gun. Kyle Rittenhouse did everything right. He tried to flee. He fell on the ground. They kept coming after him, and he admitted what he did to law enforcement afterwards. He came to law enforcement asking for their help, told them that he shot people, never denied it because he knew these were justified killings. That's going to be the defense's argument. Okay, and they're going to talk about how these alleged victims were bad people. And it's going to be up to a jury. I think this is going to be an incredibly interesting case. I am interested to hear what you all think about it. Who do you think is ahead prior to this trial starting? Just in what we know in the media, because we're going to learn things we don't necessarily know. We're going to hear it in a different way. The jury's not going to know all of these arguments and all these things that have happened like we do right now. They're hopefully going to be shielded from a lot of it and have an open mind and be fair and unbiased coming into it. Comment below who you think is ahead before this trial starts. And comment state if you think the prosecution is ahead, or Rittenhouse if you think the defense is ahead so far in this case. So that's all we've got as the pretrial setup happens for the Rittenhouse trial starting next week. But we will be following this weekly. We will be doing weekly updates if you like this video and are interested in this content. So make sure you subscribe and follow us along. But that's all we've got for now. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.